webinar today. I hope that everyone can hear me. My name is Kristine Tidgren, and I'm the staff attorney over here at the Center for Agricultural Law and Taxation at Iowa State University. And today's topic, we're going to talk about some of the legal issues that are associated with the drones, and I put that in quotes because we'll talk about terminology. We'll talk a little bit about big data in agriculture as well. So thank you so much for joining this webinar today. I hope that we'll be able to provide you with some information that may be useful for you in your practice. I've included here my contact information. My email address is there, as well as the website of the center. We do try to keep very updated information on the website. We have a lot of legal articles, things of interest, in particular to attorneys who practice in agricultural law. So we do have some information out there about unmanned aerial vehicles, and we do have a lot of information just about general ag law topics. If any of you practice tax law for your clients as well, we have a whole wealth of information on ag tax as well, including a whole separate website called TaxPlace. So if you are interested in just exploring the information that's out there, just go to the website that I have there. Address, the website address is www.calt.iastate.edu. And my Twitter handle is there as well. We do try to keep our followers updated with just the latest information that they might need in their ag law practice. And then my phone number is there as well. I do like to get phone calls, so if any of you have any good stories to tell or helpful information after viewing this webinar, or just any questions or anything like that, feel free to call me. I do like to talk to the people who've attended. So today what the plan is to go through just the current status of the law for unmanned aerial vehicles, sometimes called drones. We're going to take a look at the Federal Aviation Administration, the FAA, and why they're involved in all of this, sort of start from the beginning with the basis for their authority. We're going to look at the distinction that exists between hobby aircraft and commercial UAVs. We're going to pull up the applicable law and kind of look at the language of the statute. We're going to take a look at where the FAA stands right now as far as what's legal, what's not legal. We'll take a look at the proposed regulations that were issued earlier this year, and then look at the real streamlined exemption process that has been unveiled. So it's really sped things up, even though the regulations are not finalized. There have been a number of exemptions granted, and I'm sure that you've seen those. Some of you may have even been involved with one. So that would be good information for me to know as well. And then we're going to close with just a little look, if we have time, at some of the developments with the idea of big data and data in agriculture, and who owns it, and what some of the concerns are with that. So with that said, we're going to just take a look at the regulation of unmanned aerial vehicles. And that's the term I usually use, is UAVs. I did want to just start by mentioning that in the media, a lot of times it's called drones. I just got a question that popped up that said, is the PowerPoint available for attendees? You know, I have that, and I'd be sure glad after the presentation to mail it to anybody who would like it. So if you want to just send me an email after the presentation, if you're interested in a copy of the PowerPoint presentation, I'd be very happy to just email that to you. Again, my email address is ktidgren@iastate.edu. So yeah, feel free to send that request, and I'll get that right out to you. As I said, the media often uses the term drones. Another term that's used quite often is unmanned aerial vehicles, UAVs. That's sort of a term that I got stuck using some time ago, so it's sort of my default term. The FAA does use the term unmanned aircraft systems, UAS. So in all of the FAA regulations, proposed regulations, and communications, you'll see that term. I've been told by experts that we should probably avoid using the word drones in terms of when we're talking about these small unmanned aerial vehicles, just because the picture there depicts what a real drone is on the left. It has the connotation more of the military vehicle, whereas what we're talking about, of course, are the smaller unmanned vehicles that are used for lots of different purposes, but I think most of the people in the audience today, the purpose that's most on most of our minds is that for use in agriculture. So the beginning point of a discussion about the legal landscape with respect to these UAVs is to look at the Federal Aviation Administration and see where their authority comes from. And so it kind of goes all the way back to Congress charging the FAA with regulating all of the U.S. airspace. And so I've included the citation there. Again, I would love to send anybody a PowerPoint presentation afterwards so you can have this information if you would like. And the quote from the statute is, "The administrator of the Federal Aviation Administration shall develop plans and policy for the use of the navigable airspace and assign by regulation or order the use of the airspace necessary to ensure the safety of aircraft and the efficient use of airspace." So there's a couple of key terms in that grant of authority, but that's the overall grant of authority that the FAA has been given by Congress. And you see that the couple of terms that are important are aircraft. An aircraft is defined by statute as any contrivance invented, used, or designed to navigate or fly in the air. So you can tell from that definition, it's very broad. It would seem to include a paper airplane if you wanted it to. So it's a very broad definition in the statute itself. And then the other key term in that authority statute is navigable airspace. And so the definition of that in statute is airspace above the minimum altitudes of flight prescribed by regulations under this subpart and subpart 3 of this part, including airspace needed to ensure safety in the takeoff and landing of aircraft. And because of that latter phrase, FAA has long asserted that their authority extends from the ground up. And so that has been affirmed. That is where the authority for the FAA regulating that airspace that is below, say, 400 or 500 feet, that's where it comes from. Because there's sort of been a myth out there for some time that if you're 200 feet off the ground, FAA has no authority to regulate that space. And that is definitely not the FAA's position. So one case that I wanted to bring to your attention, because it is sort of a key case in this area of the law, and you may have heard about it last year, was the case of Huerta v. Pirker. And the facts of this case actually arose before Congress passed the FAA Modernization, Reauthorization, and Reform Act of 2012. And I'll tell you about that act after I tell you about this case. But I did want you to know that Huerta v. Pirker was not controlled by that statute. But what happened is there was a Swiss photographer, and he was flying a commercial UAV over the University of Virginia and taking aerial photographs. And he was doing it actually for compensation. So it's interesting because the case doesn't really talk about the commercial versus hobby distinction, but technically this was a commercial use of a UAV. And the photographer did not have a pilot certificate, and he was flying it in an allegedly careless and reckless manner. And so the FAA fined him $10,000, saying that he was endangering people. He was kind of flying over people, doing things that were reckless. And so he received an assessment of a $10,000 fine. And he appealed from that order. And the first thing that happened was last March, a year ago March, an administrative law judge from the National Transportation Safety Board, and just so you kind of understand, any sort of appeal from FAA regulations goes up to the National Transportation Safety Board. That's sort of the board that is the administrative governing body that will decide those types of cases. And an administrative law judge from the NTSB actually vacated the fine. And that judge said that a model aircraft was not subject to FAA regulation. The judge said that in order to have that happen, FAA would have had to have issued a special rule to assert its authority over model aircraft. And so the judge said since there was not actual formal rulemaking that had happened, there was no rule, and so there was no authority, and so the fine was invalid. So that's what happened in March of 2014. Well, a short time later, in November, the full panel of the NTSB reversed. And the board said that it really didn't have to look any further than the clear and plain language of the code provision I referred you to start with, which was the definition of aircraft. Aircraft being any device used for flight in the air. And the fact that Congress had given the FAA the authority to regulate aircraft, period. And so the full board of the NTSB took that to say, you know, this was not outside of NTSB's authority, and so the fine stands. Now, short time after that, I do believe that the photographer settled and ended up paying only $1,000 for the fine. So that case is over. It won't go any higher on appeal. But that was a significant decision, and it kind of shut down that interim argument that we were hearing a lot of, that the FAA really had no authority to regulate until the real rules came out. So let's look at what those, I guess, what the current law is, because that's sort of an important distinction for your clients to understand. There has long been a distinction between the treatment of hobby aircraft and aircraft used for business purposes. And the idea has been that hobby aircraft, using a modeled airplane for hobby purposes, you can do that. You don't need any special FAA grant of authority. That is perfectly legal. The guidelines, though, are that you have to follow, and they're voluntary guidelines, but they're safety standards. And those voluntary guidelines were issued through the Advisory Circular 91-57, so back in 1991. And those guidelines provided that the pilots would have to choose operating sites that had a sufficient distance from populated areas. They were not allowed to fly higher than 400 feet, and they had to notify the airport operator if flying within 3 miles of an airport. Those are sort of the highlights, I guess, of the voluntary rules. And so although there was never formal rulemaking, the FAA did clarify several times that these voluntary guidelines only applied to model aircraft. And that happened, for example, in 2007. The FAA clarified that AC 91-57 applied only to modelers and specifically excludes its use by persons and companies for business purposes. So bottom line, business use of model aircraft, commercial flights of UAVs have not been allowed. They're simply unauthorized by the FAA without a special exemption. So we'll talk a lot more about this, but that's sort of the starting point. That's long been the FAA position. Again, in 2011, the FAA stated that AC 91-57 was limited to hobbyists and that commercial operators had to possess a special airworthiness certificate. And so that's the quote there from that notice that was issued in 2011. The AC 91-57 only applies to modelers and specifically excludes its use by persons or companies for business purposes. Now, in the interim, we have had a congressional act passed In 2012, Congress was getting spurred on by the industry and by many people getting very anxious to use these commercial UAVs, and realized that there was no legislative infrastructure in place for them to be used. You know, the basic situation is that the uses have exploded. As you know, these are being used all over the world, but our FAA has continued to generally prohibit their use. So back in 2012, the act was called the FAA Modernization and Reform Act. Congress directed the FAA to develop and submit a comprehensive plan to safely accelerate the integration of these unmanned aircraft systems into the national airspace. And you'll note that the deadline that was put forth in 2012 was September 2015. Yeah, that's just a couple months away, and no, that deadline is not going to be reached, as I'm sure you all are aware. The Act requested a lot of the FAA. We get frustrated with the agency, but it's a huge job to create an entirely new infrastructure to sort of work these aircraft into the current airspace. There are a lot of safety issues and concerns that have arisen, and we see that on the news now on almost a daily basis, where a UAV has perhaps come close to a commercial aircraft, those types of things, not to mention all the privacy and all those other concerns that we have. But FAA has not even come close to following the congressional mandate to get this integration completed by September of 2015. Now, just to point out, the Modernization Act, the 2012 Act, specifically exempted model aircraft from FAA regulation. And the key is, as long as the aircraft is operated in accordance with a community-based set of safety guidelines and within the programming of a nationwide community-based organization. So the key is FAA will leave the model aircraft owners alone, who can continue to pilot that model aircraft just fine, but you have to operate it safely. And FAA does have the authority to step in if such an aircraft is flown in an unsafe manner. So let's look at the definition of model aircraft, because obviously this is key. In one hand, you can fly at will, as long as you fly safely and within guidelines. On the other hand, you can't get off the ground, so it really makes a huge difference whether you fit the definition of model aircraft. So the first condition is that it has to be less than 55 pounds. It has to be capable of sustained flight in the atmosphere. It has to be flown within the visual line of sight of the person operating the aircraft. So you can't have a model aircraft that's set on some kind of remote operation where you just let it go and then it comes back to you. It has to be within your visual line of sight. And then the key for most of us is that it has to be flown for hobby or recreational purposes. Now, last year, just right about this time, on June 18th, the FAA did issue a special rule, 14 CFR Part 91, which was an interpretation of the special rule for model aircraft. And this actually went into effect shortly thereafter. It was effective almost immediately. And again, this interpretive rule kind of helped us see what exactly FAA considered to be model aircraft. And it again stated that any operation not conducted strictly for hobby or recreational purposes could not be operated under the special rule for model aircraft. So there was this table that you may have seen that was included in that special rule. And it gave sort of the distinctions between what would be considered hobby and what would not be considered hobby. So the first example was flying a model aircraft at the local model aircraft club. That's perfectly fine. People can continue to do that. But if you receive money because you're flying your aircraft acrobatically and getting paid to do that, that would no longer be hobby, that would be commercial, and you could not fly that aircraft without a special exemption from FAA. If you just fly above your property to take pictures of your property to hang on your living room wall, that would be hobby. But if you are a realtor who's using your UAV to take pictures of the properties that you're selling, and you're using those pictures on your company website, that would be commercial. And again, you cannot fly that type of aircraft without special authorization from FAA. Again, using the model aircraft to move a box from point to point without any kind of compensation. If you're doing it out of the goodness of your heart, it's okay, but delivering packages for a fee would be commercial. And then the key to most of us dealing with agricultural clients is viewing a field to determine whether crops need water when they are grown for personal enjoyment is perfectly okay. So you can fly your UAV over your sweet corn plot, and as long as you're just using your sweet corn to can it for your family, or maybe give it away to your neighbors, you're perfectly allowed to do that. But you go right across the fence and you fly it over your commercial field of field corn, and suddenly you have become a commercial operation. So it's a distinction that's hard to understand from a safety standpoint, but that is the distinction that we have right now as far as what uses are acceptable and what uses are not. Now, one thing just to note, we talked about to be a model aircraft, you have to be below 55 pounds. And so if you're wondering, the weight of the aircraft is determined at the time of its use. So you have to count the fuel, if there's any payload or other equipment, all of that counts when you're talking about the weight of the aircraft. So 55 pounds is the limit. If you go over that, you cannot fly it and call it a model aircraft. Now, we had a really interesting development last October. If you were monitoring FAA communications, on October 10th, we had this notification that came out that said the FAA was requesting the cancellation of AC 91-57, which were those model aircraft operating standards that I told you about at the beginning of the session. And it said that AC 91-57 was superseded by the Modernization and Reform Act, and that the FAA's new interpretive rule in June of 2014 had made that no longer necessary. So the notice of the request of cancellation said the guidance in this AC is no longer applicable. Okay, we thought we'd crossed it off the list. But 5 days later, it was really interesting, the FAA said, oh, never mind, we did that too quickly. We're going to cancel AC 91-57, but we're not going to do it now. So, you know, there's that's still out there. But with the Modernization Act and the interpretive rule and all of that, the bottom line is that FAA would have the authority to, they would have authority over careless or reckless flights, even if you were dealing with a model aircraft. The issue is you just do not have to have a certificate of authorization. You don't have to have FAA approval to fly. You can fly those as you wish as long as you fly safely in accordance with the guidance. So the summary as far as the bottom line of where we're at right now is the FAA says no commercial agricultural use is permissible. And of course, we're going to get to the exemption process soon because that's a big deal right now. If you've been following, there have been a number of authorizations granted for agricultural uses of UAVs, but these are on a case-by-case basis. So if you just are purchasing one now and you want to go out and do field scouting or something like that, crop scouting, livestock monitoring, you cannot do that without following the proper FAA protocol. What the FAA has been doing with unauthorized flights is issuing some cease and desist orders, threatening fines. There hasn't been a lot of anything out there with major prosecutions or anything like that. So it's been fairly low key. But the required rulemaking to actually get these UAVs integrated into the airspace is, as you see, very off schedule. So we don't really know exactly when it's all going to happen, but we did have a pretty good step this spring. So all along, the FAA has said that it faces just significant technological, regulatory, and managerial obstacles. And it has given us the heads up some time ago that September 15th deadline would not be met. It did promise us proposed rules by the year end of 2014 for small UAVs. And that kind of promised deadline was not met either. However, they weren't too far off. So if you were watching in February, we did finally get the proposed regulations for small unmanned aircraft systems. So those aircraft falling within that definition would include those aircraft that weigh less than 55 pounds. One thing that was really positive, I think, about the proposed regulations is they seem to be a lot less restrictive than many people had feared. We don't know when they'll go into effect. The comment period closed in April, and we know that there were about 4,500 comments that were submitted. But it's likely that these regulations will probably not be final until the end of 2016 or later. That's how massive, I guess, this undertaking has been. So we shouldn't hold our breath to get these finalized rules, most likely. But they're less restrictive than many had feared, because some of the early exemptions were requiring a pilot's license. They were requiring some pretty significant restrictions. And so it kind of looked like that the regulations that would be issued for small UASs might include those same restrictions. But in February, the proposed regulations anyway, they established these requirements. So to fly a commercial UAS, you would have to have an unmanned aircraft operator certificate with a small UAS rating. This is a much less substantial requirement than a full pilot's license. So the only thing really that would be required for this special certificate would be a knowledge test that you would have to go take. You would have to go take it in person, because there would also be a security screen conducted by TSA agents. And then you'd have to apparently repeat that knowledge test every 24 months. So there would be that testing requirement. As with all pilots, all operators, you would have to be able to speak, read, and write English. But the proposed regulations state that the cost of this process, including the registration fee, would be only around $200. So that was, I think, important to the regulators, was to ensure that with small UASs, we would not have a large cost prohibition. That cost would not prevent a number of people from getting into the ability to fly a UAS. So the requirements that the proposed regulations have set forth is that an operator would have to keep the UAS in his line of sight. But it does provide that the operator could be assisted by an unlicensed visual observer. So as long as the two of them could keep the aircraft aircraft within their line of sight, it would be in accordance with this proposed regulation. Now, this is one of those restrictions that is having research conducted. Because, I mean, we have, especially where you guys are in Nebraska, there are lots of wide open spaces. And so one of the beauties of this technology is that you could send your UAS over this massive hundreds of acres of field, and you could have all of this done, and you wouldn't be able to visually observe the aircraft flying, but there really aren't any safety hazards as long as you stay at a certain height, because there's nothing out there. And so that is one thing that in the regulations, and since the proposed regulations have been set forth, there have been some suggestions that it kind of looks like this particular restriction, there may be some relaxation when we're talking about certain types of land. So that would be positive. The proposed regulations say that the aircraft would have to stay below 500 feet. Another of the more controversial guidelines or restrictions would be that they would only be able to fly during daylight hours. That is a big concern in certain places of the world where of the country where there are not as many daylight hours, and also just certain uses that people would like to use these for. This restriction is a big deal. And so the FAA says it is considering reasonable mitigation. So there are certain things happening right now with respect to that restriction as well. They're sort of investigating whether there's a way to expand that restriction a little bit. The flight speed would have to stay at 100 miles per hour or less. Another one that gets some pushback is that the UAS would have to avoid flying over people who are not involved in the operation. Now we'll talk about the proposed micro UAS regulation in a minute. That would relax that restriction. So again, these are just proposed regulations. They're looking at the comments that were submitted, and they're also looking at some test operations that are occurring, just to sort of try to figure out what is absolutely necessary for safety and what would become so restrictive that we would be shutting out a whole segment of very important uses. And also at this point, the UASs would not be able to transport cargo. But again, this is another area where the FAA is seeking further input. So as you can see, there are a lot of unknowns, even in these proposed regulations. The proposals are out there, but the final regulations could ultimately end up looking quite different from the proposed ones. There would be no airworthiness certificate required for the aircraft. So all that would have to happen is the user of the aircraft would have to register with the FAA just to say, hey, here's my aircraft. The operator would have to conduct an inspection before every flight, and then there would have to be the standard FAA aircraft markings on every aircraft. And that's really it. So that's a huge thing, because right now it's that airworthiness certificate that is preventing people from getting out there and flying commercially. Just to note, this rule does not apply to model aircraft, as we said. And so the key to the model aircraft, so if you're not flying commercially, if you're flying over your sweet corn or flying for pictures on your living room wall, the guideline is to continue to operate under the do not endanger the safety of the national airspace standard. So that's sort of the key language, I think, from the proposed regulations. Now, since those proposed regulations were set forth, there have been a couple of big developments. The chief of FAA, Michael Huerta, announced on May 6th that the FAA is starting to work with 3 big companies to research the safety and feasibility of certain types of flights. So as I was going through those proposed restrictions, I mentioned that there were several of those that were of concern and that further research was being conducted. Well, CNN, the news company, they've actually been tasked with researching how the visual line of sight operations could be used for news gathering in urban areas. So as long as you kept your aircraft within the visual line of sight, could you safely allow the flight of these UASs? Because if you're in an urban area, obviously you're going to be flying over people. And so CNN is investigating the possibility or the feasibility of the safety of that type of flight. Precision Hawk, an agricultural technology company, was tasked with surveying crops in rural areas using UAVs flying outside of the pilot's direct vision. So this is that large plot of land situation I was talking about, where the whole purpose or the whole beauty of the technology is that suddenly you can send this UAS out there to survey a huge field and save all kinds of time and money and effort, and it just comes right back to you and it has all of the data, and that's just a key agricultural use. So Precision Hawk right now is testing that, gathering data, and it probably is most likely that in final regulation would allow that technology to be used with certain restrictions. And then the BNSF Railroad is exploring the challenges of using UAVs to inspect rail infrastructure beyond the visual line of sight in isolated areas. So again, that's another company that's investigating the safety of flying this aircraft outside of your own line of sight. Again, that's a use for the railroad that would give them huge cost savings to be able to use that aircraft to go where they don't see, where they're not able to view. Now, as I mentioned, these are just proposed regulations. So until the rule is finalized, FAA will continue to authorize some commercial use of UASs, but to get this authorization, you have to actually receive an exemption. And this was a really big deal. It was really hard to do, and none of these exemptions were granted at all until last fall. And so that process started last fall, and it started like a trickle. But the process has recently been approved and streamlined. I think there's been so much pressure that, hey, this has been bogged down for so long. We now see that the actual final regulations will still be some time off. And so people have just been clamoring to use this technology. And so all of that pressure has made it necessary for a streamlined process. And so that has really happened. And so just a couple of months ago, the summary process was unveiled. But first, let me just tell you just a little bit about what the exemption even is. So it's an exemption. It's pursuant to what's called Section 333 of the FAA Reform Act of 2012. So that 2012 Act that I told you about, in Section 333, Congress gave the authority to FAA to say that certain UAVs, because of their size, weight, speed, etc., would not create a hazard, and that an exemption could be authorized which would eliminate the need for an airworthiness certificate. Okay, because what right now, like I said, to fly commercially, you would have to have an airworthiness certificate, and that's a complex process. It's a really big deal, and this 333 exemption says, okay, you can fly commercially, you don't have to have the airworthiness certificate, but you have to meet these requirements. And then once you receive the 333 exemption, there is a requirement for also a certificate of a waiver or authorization. It's commonly called the COA. And that gives you the permission to fly in a particular block of airspace. Now that is a much less cumbersome process. It usually takes, I think, about 30 days is what I've been hearing to get that. And there's also been a summary process for that as well. So as of January, just to kind of fill you in on how the summary process has evolved, the FAA had granted case-by-case exemptions to only 13 different commercial companies. So as of January of this year, 2015, there were only 13 companies that had the authorization from the FAA to legally fly a UAV commercially. And of those, there were 6 that were AV companies. There were 4 that were granted exemptions later in those were granted in September. And then another 4 companies received December exemptions. And then in January 6th, we actually received our first agriculture exemption. Advanced Aviation Solutions was the first agricultural company to get an exemption to fly. And so their business is crop scouting. And they received authorization to use a little 1.5-pound aircraft to do crop scouting. But that did not happen until January 6th of 2015. And at that time, more than 200 applications were still pending. What was significant about these early exemptions is they required a private pilot certificate. So the person flying them had to have a private pilot certificate, a 3rd-class airman medical certificate, and they emphasized that the private pilot certificate holders are subject to security screening by TSA. And what FAA has said recently is that it's going to rely on its initial research for the exemption request, so that when similar requests come in, those will be granted summarily. So that's what's been happening. The requirements haven't changed a lot, except beginning in April, FAA does waive the medical certificate requirement. And they also relax the private pilot license a little. So now if you have a recreation or sport pilot certificate, which is less restrictive, those are the certificate requirements that the FAA has required for these exemptions. You would still need a valid driver's license. The exemption is requiring that the aircraft be kept in the line of sight of the pilot, that there must be an observer, and that the flight has to stay below 400 feet. And then, as I mentioned, the COA authorization has also been changed to a blanket COA. So that's sort of been happening, but you have to stay at or below 200 feet to get the blanket certificate of waiver or authorization. If you want to fly higher, you still have to get the regular one. So as I mentioned, the exemptions have been rolling right along. So we have 13 in January. In June, that's a typo. As of May, there were 289 exemptions granted and 230 pending. And then as of yesterday, when I checked, there were 489 granted. So you can tell that they've really stepped up the granting of these exemptions. There was one granted in Nebraska just recently, in the last couple of days. And so, they just continue to issue these, which has given a lot more people the ability to fly commercially. So this is the way that commercial UAV flights will occur until those rules are finalized. So if you're flying fast, can I fly my UAV? As we've said, the answer is yes, if you're flying over your sweet corn or putting pictures on your living room wall. No, if you want to fly commercially, unless you apply for a 333 exemption from the FAA, and the process has become a lot easier. So if anybody wants to go out and apply for this exemption, it's a fairly straightforward process. You just go out to the FAA website. There is a place where you click for the exemption, and you fill out the paperwork, and then you wait to hear back from FAA. I just printed off sort of the latest docket to kind of show you how quickly these are coming out from FAA. These are the latest exemptions that have been granted. All these were granted yesterday. You can also see kind of the wide range of uses that are being approved. Lots of photography and videography, and there have been quite a few ag uses approved also since January. Now, you may have heard of an interesting exemption or approval that was granted May 1st. This sort of hit the news media too. And just to clarify, this Yamaha aircraft that you see there, it's called the RMAX helicopter, and it's used for commercial crop spraying. Yamaha received approval to operate this helicopter from FAA. But just to clarify, this is not a small UAS. It's 141 pounds. So this is sort of a separate type of aircraft from what we were looking at, when we're talking about the small UAS rule. So this would not even be governed by the proposed regulations, because we don't have any regulations proposed or otherwise for large UAS operation commercially. But this is a big deal because FAA did go ahead and grant Yamaha a case-by-case approval to fly this helicopter for commercial crop spraying. Now, it appears that this is not the kind of thing now you can go buy the RMAX and you're approved for commercial crop spraying. This approval was given to Yamaha. So it's Yamaha holds the right to use this aircraft. So that's sort of the way that approval works. I mentioned that the proposed rules did also include something called micro UASs. And what the proposed rules said is not these are our proposed micro UAS rules. It said instead that FAA is considering a micro UAS classification. So whether this will happen, it's likely it will, but the consideration by FAA and what they were seeking comment on is, would this be a useful classification? And how they proposed that it would work would be that the UAS would have to weigh less than 4.4 pounds. It would have to fly at an altitude at or below 400 feet. It could fly over people, so that would be distinctive from the regular small UAS rule. It would have to fly in the visual line of sight of the operator. It would still require an operator, so you couldn't put it on remote, but there would be no knowledge test. So this would be a really interesting thing, because some of the most, the most important uses for agriculture, for example, these types of aircraft can be used for them. So crop scouting and things, you could pick up one of these micro UASs and use it in your operation. So the less restrictive rules would be really helpful for something like that. Now, there are a number of other issues associated with the use of unmanned aerial vehicles that aren't even related to the proposed rules or even the FAA authorization. I did want to point out, though, that right before it issued the proposed regulations, the FAA did release some interesting guidance for local law enforcement. I had mentioned that the regulation of this had kind of been restricted to some cease and desist orders. Nothing too big had been prosecuted, but there was sort of a statement that was put out that made people realize that the FAA was serious about enforcement, and it asked local law enforcement to assist in catching and proving the suspected use of UASs in an unauthorized manner. What it said was that local law enforcement are really in the best position to detect the huge proliferation of unauthorized uses that had happened, and so it asked them to be on the lookout for unauthorized flights. It said that they were promoting voluntary compliance through education, but that a number of enforcement tools are available. And those include warning notices, letters of correction, and civil penalties if necessary. So it did say that although there are some federal criminal statutes that could be implicated by some operations, and I have a citation to a code provision that you could look at if you're interested in that, most violations can be addressed through administrative enforcement measures. But the guidance requested the local law enforcement to assist by please taking the following actions. So FAA was asking local law enforcement to identify witnesses, conduct interviews, identify the operators of these allegedly unauthorized flights, to view and record the location of the event, to identify sensitive locations where flights should not occur, to immediately notify the regional FAA Operation Center if they have witnessed an unauthorized flight, and then to collect evidence, take video, take pictures. So that was sort of an interesting call to local law enforcement to say, hey, we can't enforce this on our own, but you guys can help us. So that did get some people's radar up. I haven't really heard of a lot of extra enforcement occurring since then, but if any of you are aware of that, that would be interesting information for me to have as well. Now, there are a number of other legal concerns, as you would realize, with these unmanned flights. It's a different creature than, say, even a helicopter, of course, flying over property, because these little guys can get kind of in your space. They can fly low to the ground. They can fly fairly undetected. They can take pictures very easily. They can stream pictures. They can just do all kinds of things that have not been able to be done before. And the states are really the ones that are in charge of getting these laws up to speed. I mean, we have our current laws of privacy, nuisance, and trespass, and to some degree, yes, we can cobble together a regulatory framework that will work for UASs as well, but it's difficult because really it is a different technology. It's a different creature. We've had a number of statutes passed in states, but a lot of those have just been dealing with really narrow issues. For example, here in Iowa, our statute that was passed last year for unmanned aerial vehicles was just that law enforcement, if they took pictures using a UAV, they couldn't use that as evidence in a court proceeding unless they had a proper warrant. So it was a very, very narrow issue. We haven't seen a ton of laws yet come out. There was a lot of concern when the FAA proposed regulations came out that they did not include any privacy. They didn't include any privacy restrictions in them. And so on March 31st, there was a group, the Electronic Privacy Information Center, that actually filed a lawsuit against FAA. Now, they alleged that the proposed regulations had to include privacy considerations, and because they did not, their argument is that the proposed regulations need to be set aside and the FAA needs to go back to the drawing board. So I haven't checked that case recently to see if anything's happened with that, but that was an immediate reaction to the proposed regulations. We do get a lot of questions here at the center, and you've probably received some of those in your practice as well. Do I get to shoot down a drone flying over my property? What if the drone's spooking my cattle? Can people take pictures of my land without my permission? What if my kids are in the backyard? Can I sue for invasion of privacy? These are really important questions. And to some extent, they're somewhat answered by the current law, but to some extent, we're sort of guessing. So if you've done the legal research to answer some of these questions for clients, you may have sort of given them, well, it depends scenario. I think most people agree that no, you can't shoot down a drone flying over your property. That answer perhaps could be different if the drone is spooking the cattle to the point of risking the destruction of the cattle. Perhaps it would be like the wild animal, the animal exception when a dog comes and is damaging your livestock, something like that. There is case law about flying aircraft over property and taking pictures. But that's a different thing than you can't get a helicopter right down in somebody's yard and take pictures in the same way. So it would seem presumably that current law relating to invasion of privacy and interfering with use and enjoyment of land as far as trespass goes could apply in certain cases. But again, this is sort of uncharted territory. And I am running somewhat out of time, but I did want to just point out a little bit, get into this big data, just enough to say it is an emerging issue that has become more and more important, but it's not an issue that's, of course, restricted to agriculture. Every industry right now really is faced with the idea of big data, data collection, what can happen with it, who owns it, what's involved. There was an interesting article in Wired magazine recently. If you didn't get it, you might want to look that article up and read it. It was sort of interesting that John Deere had filed a paper in conjunction with a copyright case that said, absent an express written license in conjunction with the purchase of the vehicle, meaning a tractor, the tractor owner receives an implied license for the life of the vehicle to operate the vehicle subject to any warranty limitations, disclaimers, or other contractual limitations. This was written about in Wired because, the idea that this tractor has this technology then led John Deere to say in this filing that really what the owner gets when they get the tractor is an implied license for the life of the vehicle to operate the vehicle, which sort of got people concerned about who even owns the tractor when the tractor's all smart and wired up with the ability to collect data. There have been a couple of advances in the area of data ownership. There really isn't any solid legal framework in place at this time. I think most people agree that the current laws are fairly insufficient. So right now, it's really driven by contract. So if you have clients where this is an issue, just make sure to encourage them to have you review their contracts with their agricultural technology providers. There was a group of providers and others that came up with some big data privacy and security principles last November. If you want to pull those up, they're easily available on the internet. The key things that they set forth in their principles were that farmers own their data, but they have the responsibility to ensure that they only share the data they own with their agricultural technology provider. And that has to be coordinated between landlords, tenants, co-ops, the owners of the hardware, the software, all of that. And that the ATPs should never collect and use farmers' data without express consent, that use of the data has to be disclosed, and that there has to be some provision. Best practices would definitely say there has to be some provision for the removal, secure destruction, and return of that data when the account is closed. Because obviously there's a number of concerns when you're talking about data, that data would fall into the wrong hands. Some of that data could potentially be used in lawsuits, perhaps environmental lawsuits. They could demand regulatory responses, you know, just monitoring different types of use of fertilizer, all that type of thing. Falling into the wrong hands could be dangerous. So it's just something that everyone needs to be aware of, and we will hopefully get some more information on that. This is a copy of what our website looks like. If you want further updates or information on just different topics pertaining to agricultural law, we do try to keep it up to date. I do have my contact information here. Again, we did not have a venue to distribute the PowerPoint presentation in advance, but I would be very happy to share it with anybody who would like a copy. Just email me here at ktidgren@iastate.edu. I also do not have, I've not seen any questions in a question box or anything, and I think our time has expired. But I am very happy to answer any questions via email or telephone call. So I would appreciate you contacting me that way. And again, the Twitter handle there, CALT_Iowa State. Love to get followers and try to keep you posted on the latest happenings. So again, thank you so much for tuning in today. I really appreciate your attention, and I look forward to maybe talking with you in the future.